Welcome to Talk Business. It's Lagos Talks 91.3 and it's 4:38. It's time for us to talk about The Office. As you know, The Office comes on the radio every Thursday. And today we have a special guest with us. We have Mr. Emmanuel Abraye. He's the immediate past associate of Pitchstone and Grace, and he'll be here to talk to us about knowing our rights as employees. You're welcome to the show today. Good evening.
Thank you very much. I'm very glad to be here.
All right.
Not immediate past associate though, intermediate senior associate.
Oh, intermediate senior associate. That's good. You're also the team lead and team lead labor and employment.
Yes, thank you very much.
All right. Now, you know, sometimes employees do not know how much rights they have or if they even have rights in the first place. And because of that, sometimes they do not know how to get the best of, you know, what they deserve in the office or at their workplace. And today you're going to enlighten us, you know, so we can be exposed to some of these things that we really, really do need to know. So what protection do you foresee or do you know that employees have against dismissal? In what circumstances are an employee treated as being dismissed?
All right. Thank you very much. I'll start with the second question you've asked, the circumstances when it can be said that an employee has been dismissed. First, we must treat dismissal in two ways. Of course, I know that for everyday people, dismissal is used as a generic word, but that's not the case looking at it with the eyes of the law, because when you look at it strictly, dismissal is simply just saying that there's been some kind of disciplinary issue, and on account of the disciplinary issue, you have been dismissed from work. Termination, on the other hand, is a little bit different because it could be for reasons not related to any discipline.
Okay.
Yes. Now, when it comes to the protections that employees have in relation to dismissal, with the distinction I have made, yes. For dismissal, you have a situation where employees are protected by the law, ensuring that employees are given an opportunity to defend themselves against any allegations that have been made against them for disciplinary purposes.
Okay.
So an employer, for instance, cannot just wake up and say, you know what, you're dismissed. You have to tell the employee what he has done wrong.
Okay.
Then you have to give the employee the opportunity to defend himself against those allegations that you have made against him. And then you can then decide. When you dismiss an employee without giving him the opportunity to defend himself, that dismissal is wrongful. Now, for termination, you can't terminate an employee without giving him any reason for the termination. So sometimes employers believe they can just say, your employment is terminated because your services are no longer required. And they believe that once they've said your services is no longer required, then you have been terminated. But that is not what the law says. The law says you must give that employee valid reasons for terminating his employment. Of course, it makes sense because you can't just leave an employee in limbo. He goes here, is terminated. He goes there, is terminated. And he doesn't know why. Now, giving him reasons for the termination of his employment means that you're calling him to action. And then if the reasons you're giving him is related to, or giving her, is related to the performance of their work, then you must put them on a performance improvement plan of some sort to try to see how they improve and how they get better on the job. So those are the ways, employees are protected from dismissals. And once you have wrongfully dismissed an employee, the employee has a right to sue you and get damages for the wrongful dismissal or the wrongful termination. And where the employment is one that is statutorily protected, the employee can be reinstated back to his work.
Wow.
Yes.
That's eye-opening. So because dismissal pertains that there's been a disciplinary issue, like you said, an employer must accord any erring employee the opportunity to defend him or herself before the decision is finally reached. All right, exactly. That's good. Yes. So what are the circumstances when an employee is treated as being dismissed?
Yes.
Are there also categories of employees who enjoy special protection against dismissal?
Yes. So circumstances when you can see an employee is being dismissed. You've been given a letter of dismissal, you've been given a letter of termination, or you've been forced to resign. maybe you did something wrong, and your employer just says, you know what, I don't want to hear about it. Turn in your resignation. It can be said that the employee has been dismissed, even though constructively. So those instances, once you've been given a letter, now for employees who are in a category of being protected, for pregnant women, if they're absent from work for a prolonged period and the doctor has certified that the absence is the result of a sickness that has arisen from the pregnancy, you can't dismiss them. They are protected by law. And of course, employees who are unionized, you cannot say because an employee has joined a union, then you're going to dismiss him. No. Under the Labor Act, you cannot dismiss them on account of those two things I've mentioned.
All right. Now, employers sometimes carry out pre-employment background checks on potential employees. Is this a legal thing to do? Is there a law guiding this? When they do background checks on you, is it invasive? Can it be seen as invasive or unlawful?
Well, we also have to speak for both sides. For instance, you have an employer who wants to employ somebody into a very sensitive position. Maybe he has criminal records. Maybe he has a poor credit score. You never can tell. To some extent, employers are allowed to conduct these background checks. Of course, when you're talking about credit checks, we don't have any kind of centralized registry where employers can go to say, okay, I want to know the credit score of this individual who I want to employ. But, in those instances, you have to get specific authorization. The major thing here is consent. If the employee is giving you consent to take the actions you intend to take, it's fine. But many times, information is in the public domain. For instance, if an employee has been convicted of a crime, the judgment convicting him of that crime is public record. The employer can, approach a court and say, okay, I need the certified true copy of this judgment. And then it's in his hands. Or sometimes employers even would go to the police to say, okay, I need to know if this person has criminal records. Yeah. But when you're taking, an employee's data, for instance, and you want to use that data for the purpose of employment, then the employee's consent is sacrosanct. You cannot just go ahead and decide to use an employee's data just because you feel like you want to use it. So consent is really the guiding principle when it comes to conducting background checks and all.
Right.
Yes.
So is it okay for an employer to monitor employees' emails? I personally think about that sometimes. Is it a normal thing? Is it okay? And, even the phone calls, that's if it's been made through the office, of course. Some people seem to think that it is invasive, it's an invasion of privacy. What's your take on it? Is it okay for employers to monitor the emails of their staff to see what they talk about, what they're doing?
Personal emails, personal phone calls.
Well,
with the employee's phone?
No. I'm talking about official emails. Yes. Official emails, official phones.
Yes. So I just wanted to break that into two. It's personal, it's invasive, your privacy has been breached. Or if it's official, the email and the phone belongs to your company. And of course, many of these things are done for good reasons. Mm-hmm. Yes. For instance, a call center operative cannot complain of the calls being monitored because it's for quality assurance purposes. In fact, when you make a call into a call center, they would even inform you that the call is being monitored for quality assurance purposes or for any improvements they may want to make subsequently. For emails, your employer wants to know what you're talking about. You've been employed for a particular purpose. Are you keeping strictly to the purpose for which you've been employed? Now, but what you must take note of, or what employees must take note of, is the fact that all of these are usually contemplated under your contract of employment. Your contract of employment says strictly that, look, your email, your phone, official phone now, is the property of the company. The company reserves a right to monitor your conversations, of course, for quality assurance purposes. Then you cannot complain.
And what if that's not the case? If there is no contract, with that type of clause enlisted in it. I mean, so then what's if that happens, is it an invasion of privacy or is it still okay?
It wouldn't be privacy if it's the employer's property. For instance, you have companies where...
Is it a yes or no? Because we're talking about official emails here. So,
yes.
So when you
Would
say...
an employee be using the official emails for personal things?
Pardon me?
Your official emails. Mm-hmm. You wouldn't be using your official emails to send out personal messages to friends when you're not pursuing business. Employer reserves the right to say, okay, what has she been doing? What has he been doing?
So it's okay?
Yes. Your employer would definitely have the right to call you to question if you're doing anything wrong. It's their property. The email, the phone is different when it's your personal phone or your personal email. They can't breach that. But if it's the official emails, I mean, you'd have probably a superior who wants to know what you've been doing. I mean, your office might even have a structure where your emails can easily be monitored and they can easily see what you're doing, or a situation where there's CCTV cameras everywhere, to see what you're doing. So it wouldn't make any sense for an employer to leave the employee to use the office resources just for what they want.
All right. Thanks for clarifying that. Wow. All right. You're listening to The Office. This is Lagos Talks 91.3. The conversation continues. And of course, you can ask your questions when we open up the phone lines. Is it legal for employment to be terminated due to prolonged illness of an employee?
I can already see. You also expect me to say, no, it's illegal. You can't terminate anyone's employment because they're sick. Well, so the provisions of the Labour Act provides in Section 7 that termination on grounds of illness can only be lawful if the illness has been protracted. Now, the argument has always been that the Labour Act does not apply to all employees because Section 91 of the Labour Act says that, defines workers, those who are bound by the Labour Act, to be clerical workers and those doing manual labours and all of that. So basically lower cadre staff. But Article 6.1 of the ILO Termination of Employment Convention states that temporary absence from work because of illness or injury shall not constitute a valid reason for termination of employment.
Is there a time frame?
Of course, the convention goes on to say what would be deemed, protracted would depend on national laws. What would be deemed protracted would depend on national laws. But there's nowhere where this has been defined. But of course, your company would have your contract of employment, the employee handbook. For instance, the employee handbook would say how long you're allowed to stay out of work. For instance, it could be deemed that you have absconded if you stay out of work for 2 days without informing anyone. And if you're sick, you'd have to bring a medical report, certifying that, okay, I've been sick for XYZ period of time. You can't just leave. So it depends on the contract of employment. It could be 2 weeks, could be 1 month, could be 2 months, 3 months. Depends on the contract.
Can the company also reserve the right to not pay you for that period while you're still employed? Keep you employed and not pay you while you're sick?
No. So, when you have provisions made under the company's handbook, for instance, the company has a duty to act fast on anything that looks like an infraction of the provisions of the handbook. Now, if the company, for instance, has not acted quickly, then taking decisions like, you're not going to be paid because you didn't resume, you claimed you were sick, all of those things would be after the fact. You would need to engage the employee immediately. You notice that they have, been out of work, or they fell sick and they have not reported to work on account of that. Of course, sometimes, an employee is not able to report back to work to say, this is what happened to me. For instance, an employee is going back home and all that, and then, God forbid, gets hit by a car or all of that. Nobody really expects that he would, but for justifiable reasons, the employee can be, okay, no problem, it's fine. We hear you were sick, no problem. But just absconding from work and then coming back to claim, oh, I was sick without showing any proof that you were actually sick, that wouldn't work.
All right. Very interesting. The phone lines will be open shortly. They are 0809 1913 913, 0809 222 0913, or 0809 234 5913. Employees, know your rights. You're listening to The Office. You can call in to ask a question or give your own contributions. Is it okay for an employee to be fired based on submission of false information?
Yes.
Uh-oh.
I mean, okay, for instance, I'm a lawyer. I get employed. I tell my employers that I'm qualified to practice as a barrister and solicitor of the Federal Republic of Nigeria. Meanwhile, I was okay. This is an example. Okay, and meanwhile, that person is not qualified. You'll be fired because I mean, the condition precedent to you even getting the job in the first place was that you made a representation that you were a lawyer, and then that turns out to be false. You'll definitely be fired. Definitely, you'll be fired. And so, yes, it's proper. It's the proper thing to do.
All right, let's talk about the rights right now. What are the rights covering an employee who gets injured or dies in the course of carrying out their duties? Meaning they die at work, or they get electrocuted or something.
Yes, you'll be compensated. So the good thing is that the Employees Compensation Act makes very, very copious provisions relating to compensation of employees who are killed in the line of work, or they contract some kind of disease while working. For instance, we have COVID, ravaging everywhere. If you have a situation where an employer has not provided, a safe working environment for its employees, and then someone contracts COVID while at work and dies as a result of that. Now, the dependents of that person would be entitled to compensation. Although, yes, the Employee Compensation Act says you must come within 1 year, 12 months of, the occurrence of that death or that debilitating injury. But then, yes, employees are entitled to compensation.
When it comes to the amount, is it discretional?
Well, so to an extent, the Section 17 of the Employees Compensation Act has already, set out how compensation will be looked at in the event that, any person gets. So the court is going to be bound by, the provisions of the law to follow it strictly. Yes.
But what if they don't want to get into the legal routes? How can people or the dependents know exactly or have an idea of what their deceased family member is entitled to?
Of course, you would have, for instance, what benefits that have accrued to that deceased person on account of being an employee, unpaid salaries, pension contributions, gratuities. Those are very much separate from compensation for that. So, of course, the company has an obligation to inform the dependents of that deceased employee what outstanding benefits are accrued to that employee. So that's different from the issue of compensation.
All right. Yes. So what type of interview questions can be described as discriminatory? Like when you go for an interview, for example, they start asking you some questions, and at some point you start feeling like you're being discriminated against. What are those type of questions that could be seen as such? And does the person being interviewed have the right to not give an answer? If yes, does the law protect such a person?
Okay, so questions like, where do you see yourself in 5 years? No marriage plans there. Ladies, for instance, do you intend to have children? How many children would you like to have? How soon would you want to start having those children?
Very personal questions.
Exactly. Now, you already know that you're being primed for being discriminated against because the employer already looks at, she'll start giving birth. Then I don't think I want to, because she's entitled to taking, leave, maternity leave and all that. So you have employers who might really not want to, are you HIV positive? No. Yeah.
Wow.
So those things happen, and those questions, any question that looks like is trying to, distinguish you for unfavorable treatment can be seen as discrimination.
Even if they ask about your religion?
Oh, of course.
Your tribe?
Yes.
Let's take some calls right now. You've been listening to The Office. This is Lagos Talks 91.3, and we're discussing knowing your rights as an employee. Phone lines are 0809-234-5913, 0809-191-3913, 0809-222-0913. You can call the landline numbers as well on 01-515-1913, 01-515-0913. Lagos Talks, good evening.
Good afternoon.
Hello, good evening. What's your name? Where are you calling from?
My name is Samson from Lagos.
All right, Samson, let's hear you.
So, regarding the topic you're talking about, so where I'm working now, so I'm a driver. So where we are working now is a Chinese company, and then there is nothing like employment letter. Rather, we are just employed based on qualification of what you're doing. So, if somebody gets injured in line of duty, then is he entitled to, or is there any legal backing for getting any compensation in that kind of a company?
That's a good question. Thanks for asking. Over to you, sir.
Yes, the answer to that is yes. Okay, so although the Labour Act says you must be given a letter of employment within 3 months of your employment, even if you're not given that letter of employment, you're still employed. I mean, it's an issue of fact. You can be employed orally. You can be employed in written. Whatever the case is, what needs to be established is that you're an employee of that particular company. And if you're injured in the line of duty, you're definitely entitled to compensation. Of course, I know that some employers do not give out employment letters because, it's easy. Because sometimes when you sue, you have to establish certain things. One of the ways you can establish that you're an employee of a particular company is to tender your employment letter in court. But even if you do not have an employment contract, all you need to do is show how you are employed. And of course, your salary, it's paid usually by maybe in cash, or they transfer it to your account. That's proof of employment right there.
What if your employment letter gives you or shows the specific job you're supposed to do, but while being employed, you're being asked to do way more, many other things that you did not bargain for, you might be qualified for, but that's not on the basis at which they employed you for, and they start forcing you or making you do work way harder than you expected to work. With that scenario, what exactly can the employee do? Is there any law covering that?
Yes. Now, the position of the law is very simple. You cannot your employment, the material, terms of your employment cannot be changed without your consent. And when an employee is put in a situation where they are being asked to do more than they've been employed for, and it puts that employee in such a situation that the employee cannot be reasonably expected to continue, working, you've constructively dismissed that employee, and the employee is entitled to damages on account of that.
All right. You've been listening to Talk Business. This is The Office. And you've been listening to Mr. Emmanuel Abraye. He is the Intermediate Senior Associate of Peachstone and Grace. He's also the team lead, Labor and Employment. Let's take this last call before we wrap up the show. Lagos Talks, good evening.
Hello.
Good evening to you. What's your name? Where are you calling from?
I'm calling from Oloda.
All right. Let's hear you.
Okay. I'm actually considering a situation where
Hello.
they're working for years. And the company is telling you that they want to downsize their salary. Then at the same time, they're taking a quitting.
We didn't hear your question. Sorry. Please go over it again. What did you say?
I said, can you make money for settling, let them paying you off? Maybe when they say your service are no longer required, let them pay you off lump sum.
Okay, I think I understand what he's trying to say. So I think what he's trying to talk about is redundancy. So sometimes you'd have a situation where the workforce is much more than the company actually needs to, continue as a going concern. And then they might decide, okay, we want to reduce our workforce. Section 20 of the Labour Act actually makes provision for what should be done in that particular instance. You are to negotiate, the exit benefit of those affected by the redundancy with either their representatives or any union that they are under. And if the employees are not unionized or they happen to be senior cadre employees not bound by the Labour Act, you're still going to have to negotiate those terms of their exit with them. Because, it's involuntary exit. They haven't resigned. You are the one who has said, oh, manpower is more than what we actually need at this point. So you're asking them to go. It's a no-fault termination,
right.
So you have to compensate them for that, and then you would have to negotiate those exit payments with them.
All right. Lagos Talks, good evening. Oh, sorry about that. Drop calls. I think I'm trying to understand this message here, but it's saying, is it right for an employee to be terminated because the employee gave the CEO's number to a vendor who used to have or who claims to have had his number before but lost it? Is it okay to give the number?
Well,
and be fired on that ground?
You're breaching his privacy. So.
Right. You're supposed to ask for his permission, right?
Yes, you should have asked for permission and obtain that before you do that.
Lagos Talks, good evening.
Yeah, good afternoon.
Yes.
It's Abu Sabanes from Alagbado.
Good evening. Go ahead.
Thank you. You see, our experience varies from one to another, from different administration, from different multi-international states, most especially in capitalist world. What we call corruption here, it's not corruption, it's corporate crime. My own observation from capitalist world, corruption is an idea of bringing money from treasury, heavily loaded treasury, like United States, we have $40 trillion in circulation and reserve, respectively. So the circulation for the benefit of...
All right, we're not discussing corruption. We're discussing employees know your rights. We're talking about the law and you as an employee of any organization. Lagos Talks, good evening. Hello.
Yeah, hello, good afternoon.
Hi, what's your name? Where are you calling from?
Sorry, I would like to remain anonymous, okay? I turned on the radio and I was listening to part of your discussion.
Okay, go ahead.
I'm just being concerned because there are a lot of Nigerians that are working with most of these foreign companies in Nigeria, and the ill treatment they give to Nigerians are bad. Okay, I'm sure that about the labor force and other stuff like that. I just hope if there's a way, Mr. Emmanuel, yes, at least if there's a way you guys can do an underground investigation and to see how Nigerians are going through pains with all of this. Most times there's some companies that most Nigerians get injured, they don't insure them, they don't pay them. There are some, they owe them salaries and blah, 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 stories like that. Okay, like I said, I'm just being concerned. That's all. Thank you very much.
All right, thank you for calling.
Okay, well, thank you very much. Well, I understand what he's trying to say, and I understand him quite clearly. But, you have a right to approach the courts to ventilate whatever, ill feelings you might have towards your employer. Whatever they have done wrong and whatever they are currently doing that, do not speak to good labor practices, you are entitled. So the good thing about Nigeria is that the National Industrial Court has powers to enforce international best practices against employers. So if you have a situation where you're being ill-treated, you have a situation where your employer is not giving you your dues, or you're being mistreated generally, you have a right to, of course, approach a lawyer. I mean, many lawyers would even work for you on a contingency basis. I mean, they'll take on your matter, they will go to court, and if they win, they're entitled to share a part of the money you got from the court. But many times I find that many people do not want to approach the court because many people have they just feel, it's going to take all my time. What will I be doing at the point when I'm in court? Because of course many times your employer is going to fire you on account of of course you are entitled to damages for that as well. But I mean, it goes beyond independent persons like me, because he has asked me to undertake an investigation. Yeah, I don't think I would want to do that. But I mean, I understand him. He has called in anonymous. He can also do some kind of anonymous work, investigating all of those things, getting everything he needs to get, and then approach the courts too. They can even aggregate themselves. And
if they have a union,
yes,
yeah, or even
yes.
if they don't have a union, they can come together.
They can come as as a class, as a group of persons concerned about what's going on. Of course, it's usually going to be hard to get all employees on board. Some people would rather not, because I mean, no matter what they're going through, they're getting their daily bread from there, so they would not want to do anything that would give them any kind of temporary discomfort. But I mean, you can always approach the courts to ventilate your grievances. I mean, even if you meet a lawyer, a simple letter can solve all of that.
We have so many calls coming through, so many questions. Lagos Talks, good evening.
Hello, good evening.
Yes, what's your name? Where are you calling from?
My name is Ike. I'm calling from Lekki.
All right, Ike, let's hear you.
Actually, I'm calling in respect of some Nigerian employers. For example, I used to know somebody at, at the mall in Festac. This guy employs people. He employs people after 3 months under the guise of non-performance or underperformance. He will sack them, employ new sets. After 2 months or 3 months, under that same guise of non-performance, he sacks them, brings in new sets. And the funny thing is, during these 3 months, he doesn't pay them. He will tell them that they're on probation. This guy has been doing this thing for, let's say, nothing less than 2 years. When I got to know about it, I told them, why don't you people go to court? That was when I got to find out that after the interview, they will tell you, okay, come and start work. No employment letter, no nothing. Come and start work. At the end of 3 months, you are not performing well, leave. They'll bring in a new set. And that's how the guy has been running his shop or whatever, without paying people. And because they feel that they don't have the money, nobody has ever taken this guy to court.
All right.
I'm talking about Nigerians to Nigerians now.
Right. All right.
Well,
I'm hearing that for the first time, but I'm not even surprised too.
I'm not shocked either. But the thing is just this. You cannot terminate, and employers need to know this. You can't terminate your employee's contract of employment on the basis of performance without giving them an opportunity to improve on that performance. And if you terminate them without giving them the opportunity to improve, you've wrongfully terminated their employment. And they're entitled to damages for that. So many times I find that employees do not want to go to court. I mean, sometimes you even have other instances where an employer would employ somebody and then refuse to confirm them. I mean, all of those are things that are actionable in court, and you can get damages for all of those wrongful actions. I think Nigerians would need to get bolder with asserting their rights, employment rights in particular. And I know it can be very tough, but I mean, if you've already been sacked, what else can you lose? Go to court.
Right? I know,
Go
right?
to court and enforce your rights.
All right. We have to stop here because of time. We do appreciate you for coming in today.
Thank you very much.
The Office is on your radio every Thursday on Lagos Talks 91.3 every Thursday from 4:30 to 5 p.m. We took a little more time because we had a lot more to discuss, and of course to give people more opportunity to join in the conversation. You've been listening to Emmanuel Abraye. He's the Intermediate Senior Associate of Pitchstone and Grace, and it's a pleasure that we had you here today.
Thank you very much for having me.
We look forward to next week. You never know who would have next and who will be speaking or what we'll be speaking about. So make sure you're always tuned in every Thursday from 4:30 on The Office, only on Lagos Talks 91.3. Coming up next is we have an interview, and later on we have critical thinking. Stay with us.
We are Lagos Talks 91.3. Let's